As with any professional occupation, there's always laws and regulations that we all have to comply with. And lending, financing is certainly not exempt from that. There are some laws, financing laws, that must be complied with. And even though I know we as real estate agents, we're not going to be the lender, hopefully. Um, but you still need to know and be familiar with some of the legal requirements here because some of them have a pretty significant impact on us as real estate agents. Um, Plus, they could ask you about some of the stuff on the exam. So that's another good reason to be familiar with some of these financing laws. Well, we start out looking at this, the Real Estate Settlement and Procedures Act, or RESPA, we hear referred to quite often. But this is a law obviously established in 74. There's been some revisions, additions, and so forth to the law since then. But this law was passed really to protect consumers, just hopefully for the same purpose any law is passed. But what used to happen, that hopefully we've got this thing fixed now, or the problem fixed. But if a consumer went to see a lender about getting a loan, one of the requirements the law required is that the lender had to provide that borrower was at the time we called a good faith estimate. It supposedly would list all the cost of the loan. So buyers should have a right to know how much is this going to cost me to borrow this money. Obviously, you need to know that as a consumer. The problem is, even though the law required lenders to provide a good faith estimate, for whatever reason, apparently the law did not require that the good faith estimate be accurate. So what lenders would do is they would leave off many of the costs associated with the loan. In fact, you would look at the good faith estimate and say, well, this isn't bad. This isn't all that expensive. And obviously part of that good faith estimate would show whatever that APR would be. Remember, we talked about that annual percentage rate, right? Because if you add up all the costs, and now you've got your total cost, which includes interest and so forth, divide that by the loan amount, that gives you a percentage, and that's your annual percentage rate. That's the APR. So there, now you know what it would cost. The problem is because they left off so many of the cost, it was just not accurate, obviously, but it looked good to the consumer up front. But then by the time you got to the closing table, if you were paying attention, you notice that APR was a lot higher than what they initially told you. So some of the more recent laws and updates to RESPA, which we're going to talk about as we go through, has basically now required that they actually changed the name of the good faith estimate. They now just call it a loan estimate, not a big deal. But now the law says it must be accurate. So they got to list all the costs, have an accurate APR, and whatever they disclose to you on that loan estimate, that's what it pretty much better be when you get to the closing table as well. So that's just sort of the background, some of the background under this RESPA. Obviously, it was put there again in an attempt to protect consumers. Hopefully now they can make a much more informed decision about the loan. Now, who enforces this act or this law? The Consumer Financial Protection Bureau. That's who enforces it. They oversee all the regulations under RESPA. Obviously, this was all included years ago. For any of you old enough to remember this, years ago, Congress passed something called the Dodd-Frank Act, which was geared towards regulating lending, financing. And in that legislation, they put this RESPA under the purview of the Consumer Financial Protection Bureau. So that's their responsibility. Now, they also came up, so in fact, if you look at that last bullet, it says the TILA RESPA integrated disclosures, combined disclosure requirements from RESPA and the Truth in Lending Act. So, y'all, the Truth in Lending Act, y'all, that's some of the stuff I was just describing to you, some of the requirements here. But they've combined Truth in Lending with RESPA. So it's all basically one big bill now. And they now call it the TILA RESPA Integrated Disclosures, or TRID is what you hear most commonly referred to as now. So when we are preparing to close, there are many disclosures that have to be made now primarily by the lender under these new TRID laws. Again, because TRID now combines RESPA and TILA, which is the Truth in Lending Act, combines it all together. So let's look at some of the things we need to understand about RESPA now. Y'all, one, there are some things that are prohibited, and the main thing that involves real estate agents would be kickbacks and referral fees. Y'all, those are now a no-no. Y'all, back in the day, it was pretty common. People did it. And basically what they're talking about here, y'all, you would have lenders would contact you if you're a real estate agent. So the lender would contact the real estate agent and say, hey, look, let's be friends. Any buyers you have looking to get a loan, if you'll refer them to me, then I will give you $500 or $1,000 back after it closes. Now it's a kickback in exchange for the referral. And y'all, obviously that's now illegal. You can't do that. And the reason you can't is because, y'all, who was paying for that kickback? Y'all, that $500 or $1,000. Y'all, the lender would add that on to the buyer's cost of the loan. So that's entirely unnecessarily driving up the cost to the consumer. So this is a very good requirement here, so now you can no longer receive kickbacks. Now, we do need to talk about this a little bit. Y'all, there's nothing wrong with you referring buyers to a lender or any other settlement service provider. Now, first of all, what is a settlement service provider? It's anybody providing a service in connection with the real estate transaction. Obviously the lender's providing a service, the attorney, appraisers, home inspectors, surveyors, you name it. You could have a laundry list of service providers that's providing some service in connection with the transaction. And what RESPA is saying here, this is not just for lenders, but you can refer to any service provider as long as you don't expect or receive anything in return or anything of value. Doesn't even have to be money. The law says you cannot receive anything of value in exchange for referral. Okay? So you're going to be making referrals. You're going to ask your buyer, well, have you talked to a lender? Well, I don't really know anybody. Could you recommend somebody? You can refer them. Buyer, you're going to need an attorney. Who would you like to use to close this transaction? Well, I don't know a real estate attorney. Do you have any you could suggest? So again, there's nothing wrong with you referring them to particular providers. Again, as long as you do not receive anything in connection with that referral. You cannot be compensated for the referral. That's a no-no. Can't do stuff like that. But so now, let's look at something that is permissible. We call it cash rebates. I don't know how common that is, at least in my market. You don't see this very much. We used to. It used to be a much more common thing. And I think I know why you don't see it as much, and I'll touch on that here in just a second. But first of all, what is a cash rebate? This is what some agents would offer primarily to buyers in an effort to try to get the buyer to use them as their buyer's agent. So what they would say to the buyer maybe is, buyer, if you'll let me be your agent and let me represent you, I will rebate you $500, or I'll give you $1,000 at closing if you let me be your agent. Obviously this is money that's coming out of the commission they would have made. So whatever amount of commission they would have made, whatever they promised to that buyer will be deducted from the commission, and it goes to the buyer. We just called that a cash rebate. Now, one of the kind of issues with stuff like this, obviously it has to be disclosed. This cannot be an under-the-table transaction between you and the buyer. It has to be disclosed, and it has to be disclosed on the settlement statement. We call it a closing disclosure. We'll talk more about that here in just a second. But when you go to closing, there's a settlement statement, for both the buyer and the seller, again called a closing disclosure. And if you're going to offer a rebate, it has to be on that disclosure. You have to disclose everything you're doing. If it's not on there, that's considered an under-the-table deal, and I will tell you that's illegal. But you can offer these cash rebates as long as it's fully disclosed. That's what this whole RESPA is about. Full disclosure about everything, all costs involved. Well, why might this be a problem? Because I'm telling you, many lenders, especially depending on the type of loan the buyer's getting and maybe some of the circumstances around that loan, the lender may not allow anybody else to give them money. And obviously that's what a cash rebate does. So as long as the lender's okay with it, and how do you know if they're okay with it? Is if they approve the disclosure, right? But don't be surprised if they come back and say, no, absolutely not. Buyer's not getting any cash back at closing. We're not doing that. It used to be fairly common, but nowadays it just seems like lenders, they just fuss about it so much that I don't think it's even something most people offer anymore. Certainly not in this market. But they are legal to do, so I just want to make sure you understand that. As long as it's fully disclosed and everybody's okay with it. That's a cash rebate. Now let's talk about these settlements, the settlement statement, the closing disclosure, and some of the documents that must be used in disclosing information for closing. Remember earlier we talked about the lender must provide the buyer with a good faith estimate. That's what we used to call it prior to TRID forming. But once TRID was passed here several years back, they changed the name to a loan estimate. And the loan estimate, as I said earlier, now it has to be accurate. The lender must include all the costs associated with that loan. And then that, which obviously would allow you to generate the APR, so you know what it's going to cost you to borrow the money. And that's a document that has to be provided up front. Obviously, if I'm the borrower, I want to know that before I get too deep into this process. But that's the loan estimate. The other document is called the closing disclosure. This document actually takes the place of what we used to call the HUD-1. HUD-1 was the settlement document that we used for years, which I never liked that document, because on the HUD-1 you had all the buyer costs, their debits and credits, along with all the seller's debits and credits, all on the same sheet of paper that both parties would get a copy of. And I never liked that. Y'all, if I'm the seller, I didn't want the buyer seeing how much I'm making on this sale or whatever. Y'all, just none of their business. To me, I thought that was always confidential information. But now that TRID has been put into place, y'all, TRID says we're not using the HUD-1 anymore on your typical real estate transactions. Y'all, there are some types of transactions the HUD-1 still used, but primarily if it's a residential real estate transaction, now it's called a closing disclosure. And you'll have a buyer's closing disclosure, and then you have a seller's closing disclosure. Y'all, two separate documents. So the other party cannot see what you're doing, what your numbers add up to be. So I like that a lot. You'll see as we get a little further along, y'all, this closing disclosure has to be provided a minimum of 72 hours, y'all, 3 days prior to closing, to give the buyer and the seller opportunity to review it, make sure they understand it, they agree with all the costs and so forth associated with this transaction. So all that has to be disclosed. Okay. Now, so what type of transactions are affected by RESPA? Y'all, basically any residential loan. Y'all, any loan associated with residential property. It says here that residential properties anywhere from single family or 1 to 4 dwelling units. So a single family home, duplex, triplex, or quadruplex would all fall under these RESPA regulations and procedures. Okay. But y'all, what I want you to pay special attention to here, y'all, you notice this is just residential properties. Y'all, RESPA has no impact on commercial loans, for example. And there are some other types of transactions where RESPA would not apply. And we're going to look at those next. But the main thing I want you to understand is, y'all, RESPA only applies to residential home loans. And so what kind of loans might that include? Y'all, loan assumptions. Y'all, if it's for a residential home. Finance or refinancing, rather, for a residential home. Home improvement loans. Home equity lines of credit. Y'all, these are all loans associated with a residential home. Okay? So all of these would fall and apply to the Real Estate Settlement Procedures Act. So what kind of loans would not fall under RESPA? One, commercial or business loans, which we just talked about. Highly recommend you remember that. But vacant land or agricultural land does not apply. Tracts of land with 25 acres or more. And then it says certain construction loans and certain loan assumptions would not apply. Y'all, the reason it's saying certain is because, y'all, if it's a construction loan for a residential home, then it would apply. But if it was a construction loan for a commercial building, it would not apply. Same thing with loan assumptions. Y'all, if you're assuming a loan and it's not a residential loan, then obviously RESPA would not apply. Okay? So those are some of the laws that you need to be familiar with. We're going to break this down a little bit more as we go through. But that is the Real Estate Settlement and Procedures Act.